a zero-sum game. Every time a song breaks through, it means another artist does not. UMG's choice to saturate the music market with Not Like Us comes at the expense of its other artists like Drake. As Drake is Petitioner's sole owner and Petitioners own the copyright to Drake's entire catalog, Petitioner suffered economic harm as a result of UMG's scheme. And if I did not mention before in part 2, in relation to who Mr. Duckworth is, Mr. Duckworth is actually Kendrick Lamar, the rapper. Let me continue. Petitioner's Frozen Movement LLC is a limited liability company registered in the state of Florida. Frozen Movements is an entity wholly owned by Drake, through which Drake furnishes his recording services as a vocalist and musician, and is the copyright holder of Drake's sound recordings, including music videos. As such, Petitioner competes with Interscope. Respondent UMG is a wholly owned subsidiary of Universal Music Group, a publicly owned limited liability company incorporated under the laws of the Netherlands. UMG is a Delaware corporation registered to do business in the state of New York. UMG has offices at 1755 Broadway in New York. UMG has divisions including, but not limited to, Interscope, which represents Mr. Kendrick Lamar Duckworth, and Republic Records, which represents Drake. Interscope's publicity team operates out of the 1755 Broadway office. Respondents: Spotify USA Inc. is a Delaware corporation with headquarters in New York City at 4 World Trade Center, and that is the address. Spotify is a digital music podcast and video service. Next chapter, jurisdiction and venue. This court has personal jurisdiction over UMG pursuant to CPLR 302. UMG regularly transacts business within the state, including by doing business and entering into contracts with New York-based Spotify, licensing and promoting music to streaming and radio broadcasting services within the state, and supplying its music management and publicity services in the state. The events at issue include UMG's licensing contract with Spotify and payments to New York-based radio stations to inflate the popularity of the song occurred within the state. UMG also owns, uses, or possesses real property at 1755 Broadway office, where it hosts offices for its catalog division and publishing arm, Universal Music Publishing. UMG employs numerous individuals within the state as its marketing partnerships and media properties and publicity professionals. Groups operate out of its New York offices. This court has personal jurisdiction over Spotify pursuant to CPLR 302. Spotify regularly transacts business within the state, including by doing business and entering into contracts with paying and non-paying subscribers based in New York and promoting its streaming services within the state. The events at issue, including Spotify's licensing contract with UMG, occurred within the state. Spotify uses its 4 World Trade Center address as its corporate headquarters in the United States and employs numerous individuals within the state. Venue is proper pursuant to CPLR 503C because a foreign corporation authorized to contract business in the state shall be deemed a resident of the county in which its principal office is located. Additionally, pursuant to CPLR 503A, a substantial part of the events or omissions giving rise to the claim occurred in the county of New York. Next chapter. Petitioner requires pre-action discovery and preservation. Frozen Moments has commenced the special proceeding pursuant to CPLR 3102C to seek pre-action discovery to allow petitioner to 1. Identify appropriate defendants and frame a complaint for a claim under the Racketeer Influence and Corporate Organizations Act, better known as RICO. And 2. Identify appropriate defendants and frame a complaint for a claim under Sections 349 of the New York General Business Law, the New York Deceptive Business Act, and Section 350 and 350A of the New York General Business Law, the New York False Advertising Act. Civil RICO. Petitioner has a viable cause of action for civil RICO, with predicate acts of wire fraud, mail fraud, and or bribery for UMG's payment to unknown third parties in the form of reduced licensing fees to Spotify. However, petitioner requires additional information in order to frame his complaint and satisfy the heightened Rule 9b pleading standard applicable to complaints sounding in fraud. Specifically, petitioner requires information about the method by which the third parties were paid in order to determine which underlying predicate acts to plead, and requires information about which benefits were conferred upon UMG in exchange for payments. Additionally, petitioner lacks sufficient information to identify the third parties who acted in conspiracy with UMG. Actually, that is a very good identification for a lawsuit right there. Drake definitely has some good lawyers if you want to make this into a RICO. Let me continue. I do not want to add too much of my own opinion into this. Next chapter, deceptive business practices and false advertising. Petitioner has information that agents of UMG paid at least one third party to use bots to stream the song on Spotify, and on information and belief, this practice extended to multiple third parties to artificially stream the song and video. UMG also gave financial benefits to Spotify and other unknown third parties to promote and play the song and video without disclosing those payments. UMG then touted the success of the song and video, knowing the success was artificially inflated by its own manipulation. These practices harm consumers. They also violate the New York Deceptive Business Act and New York False Advertising Act without the requested pre-litigation discovery. Petitioner lacks sufficient evidence to identify the known but anonymous third-party streamer and to identify any additional streamers whom UMG paid. Petitioner also lacks facts to frame the complaint regarding what was exchanged for UMG's payment. Petitioner seeks the following limited pre-action disclosure from UMG. The UMG requested information: 1. Documents and communications sufficient to show identities of all third parties that UMG, its agents, or anyone working on behalf of UMG Interscope paid without public disclosure to promote, publish, or recommend the song, its accompanying cover image, the image or video, including but not limited to radio stations, influencers, music platforms, and music publications, as well as the dates, methods, and amounts of those payments. 2. Documents and communication sufficient to show the identities of all third parties that UMG's, its agents, or anyone working on behalf of UMG or Interscope paid to use bots or any other similar technology to stream the song or video, as well as the dates, methods, and amounts of those payments. 3. Documents and communications sufficient to show what the third parties agreed to provide and did provide in exchange for those payments. Petitioner seeks the following: limited pre-action disclosure from Spotify. The Spotify requested information, the documents and communications sufficient to show the dates, methods, and amounts of financial benefit, whether in the form of direct payment or reduced licensing fees, provided to Spotify by UMG, Interscope, its agents, or anyone working on its behalf in exchange for the promotion, publication, or recommendation of the song on Spotify. And 2. Documents and communications sufficient to show what Spotify agreed to provide and did provide in exchange for any benefits. I am going to conclude part 3 right there. You guys make sure that you like, share, and subscribe. This lawsuit might have very deep implications for anyone else associated with UMG. And I have a lot of commentary, my own opinion about this. However, I am going to save that in hopes of being neutral as I report on this, I guess, pre-lawsuit. So definitely like, share, subscribe. I'm going to come back with part 4 very briefly. Like, share, subscribe. Till next time, be safe. Enjoy your day. Bye, guys.